So
That's when it's
it's
going to start.
well, but the point is, once the 52,000 is exhausted, it's very clear there is no, it's a set amount. I don't know.
The judge draws a clear legal line here. Temporary convenience does not override a standing status quo order. While cost savings sound reasonable, courts prioritize asset protection until trial. Should one spouse shoulder all expenses during divorce, or does stability matter more? Drop your thoughts. This balance sparks heated debate in family law cases.
Petit versus Petit. This is file number 2520096. If I could have both counsel put your appearances on, starting with plaintiff.
Good morning again, Your Honor. Jennifer Dusman-Cohen on behalf of Jessica Petit, who is present with me in my office.
And Zach Backlund on behalf of the defendant in this matter, Your Honor, Monty Petit Jr., who is seated to my left with me in the office.
All right, we're on the record here today. We've got a number of motions filed by both parties. We do have a trial date set for November 14th, so in less than 2 weeks. So in terms of the motions, I guess we'll just start with plaintiff's motions first. As plaintiff, Ms. Dutzman-Coy, you've got a motion regarding insurance. You're asking to have, I believe, Ms. Petit be able to change insurance and remove on her vehicles, and then have Mr. Petit removed from her health insurance. Is that correct?
That is correct, Your Honor.
Any argument as to that motion?
Well, as we stated in the motion, my client has the two vehicles in her possession, and so they're her vehicles to drive. Mr. Petit has his own vehicles to drive, and he's already taken responsibility for those policies of insurance as well. So we were simply asking so that she could have a cost savings, because right now she's been shouldering all of the parties' marital bills. She wanted to decrease the amount of the premium that she has to pay, and she'd like the opportunity to do that. And given that she's the one driving the vehicles, that only makes sense to us. And as to the health insurance, she is paying for that insurance without contribution from the defendant. This is her open enrollment period, and so she was seeking an order so that she could essentially eliminate Mr. Petit now from her health insurance. I understand that he is allegedly claiming that he has some significant health issues, but I don't have any information about that. That seems to be a new claim. And so I don't know that he has even significant expenses related to that are uninsured in the first instance. So we don't feel that that's really even a good argument for him to remain on her insurance. So we were simply asking that the court grant her that ability to change the policies of insurance at this point in time.
So just a question about the auto insurance. The vehicles are in her name?
Yes.
And the insurance policies are in her name?
Are both of you insured on the policies, or
we were, but I want to change the car insurance, and the house insurance would have to change, so it's a combo.
Oh, the house as well. Okay.
So mine is still on the house insurance that way. So
okay, thanks. So my understanding then, Judge, is that both parties are on the house insurance. She would want to essentially, are you going to be changing the company that has the house insurance and the vehicular policies? I see.
Yeah, because I can get it a lot cheaper switching companies.
All right, so it's for a rate change. I mean, you just want to be able to shop around. Is that kind of the
actually
idea?
I had shopped around it, but I got it a lot cheaper, but I didn't switch anything. So, because we have it Farmers, and I was going to go with Liberty because they were like half the price.
All right. So the only way this would affect Mr. Petit would be the home insurance and making sure that that asset is protected.
Right.
Okay, Mr. Backlund, just as to the vehicle and the home insurance issue, do you have any objection to that, or what's your position on that?
Our position is simply, there's a status quo order in place that was requested by the plaintiff, Your Honor. And, certainly we want to make sure that the insurance policies provide the coverage so that if anything were to happen to the house or the vehicle, that value is not lost as we're dividing up the assets and the liabilities of these parties. And so when it comes to the house and the car, certainly if we don't have an agreement, those issues are going to be decided, at trial, what happens to those. And when those assets are awarded, presumably each party would be responsible for all costs associated with those assets. And so if Ms. Petit was awarded her car, for example, she would be able to change the policies at that time because the status quo order would presumably extinguish upon entry of that judgment of divorce.
Okay, and then with regard to the health insurance?
Certainly, our same argument applies for the status quo order that was sought by the plaintiff, and she's paying that insurance, and that's something that she did during the marriage through her employer. Mr. Petit does have health appointments and prescriptions that are necessary to be covered. He is seeking his own employment, but again, pursuant to the order to maintain the status quo, Ms. Petit was to remain the provider of the insurance for Mr. Petit during this process. So we would ask that that continue through entry of the judgment of divorce.
Okay, Ms. Stutzman-Coy, any further response?
Not specifically, Judge, but again, as to, I guess I will say, as to the defendant's health, my understanding is that these aren't significant health conditions that he has. He's had this pituitary adenoma, I think, since the mid-2000s. He's continued working full-time since then, and it's his layoff, to my understanding, was not because of health concerns or anything like that. As far as I know, there's no exorbitantly priced medications, and so I feel like that's kind of a non-issue as it relates to his health insurance. And eventually he's going to have to get his own health insurance anyway. And when the parties get that judgment of divorce entered, he's going to have his own policy of insurance because he can't remain on the plaintiff's insurance at that point. So it's just an expense for her that she has. Again, she's the one shouldering all of these expenses. And so she's asking for some relief.
Okay. All right. So first of all, I mean, the court notes that we do have an imminent trial date. So a lot of these issues will be addressed. The court also notes that there is an order in place, a status quo order. With regard to the car insurance, number one, I think it's likely that those are marital assets that Ms. Petit is going to be awarded either by agreement or by order of the court with regard to the vehicles. So the court finds that, number one, there wouldn't be any prejudice really to Mr. Petit. Number two, it's in Ms. Petit's own interest to preserve those assets. There are things that she's likely going to get. And so I don't find there would be any motivation on her part to get inadequate coverage or somehow not protect those assets. And if she can get a better rate and save some money, I just don't see any reason why she shouldn't be able to switch the car insurance if she wants to do that. So the court will grant the motion regarding the vehicle insurance on the vehicles. With regard to the home, that's a marital asset that's going to be subject to division. I think, again, given the current order, given that there's an imminent trial date, given that that's a substantial asset, the court finds that the home insurance should remain as it is until the divorce is resolved. And same thing with the health insurance. Again, I think given the current status, it would be appropriate to continue that status quo order and have Mr. Petit remain on health insurance. So the court's granting the motion regarding the cars, denying the motion regarding changing home insurance or removing defendant from health insurance pending, again, our trial on November 14th. The next motion is regarding the mediation agreement. Ms. Stutzman-Coy, you're alleging that the defendant has violated that agreement by making negative comments about the plaintiff, by returning to the marital home, by using plaintiff's email, and I'm not sure if this was a violation of the order, if you're just making this request that the defendant get a forwarding address so his mail is not going to the home anymore. Is that an accurate recitation?
It is, Judge.
Okay, anything that
I'm sorry.
No, that's okay. Anything you wanted to state by way of argument?
Just to clarify, Judge, we were requesting that the defendant get a new mailing address because of the inconvenience and the expense to my client of his mail continuing to come there. And again, we would point out that the mediation agreement is a binding agreement on both parties, and the defendant has agreed several times essentially to not talk about the plaintiff to the others, and he's continuing to do that even since we filed the motion. Now he's calling Ms. Petit the plaintiff to the party's children, and then he's also been talking to the party's realtor as recently as last week. Told him this story about her allegedly having an affair, which did not happen, has not happened. And continuing just to talk to her in a negative light when he agreed not to do that. And so we would ask that he be held, essentially, I don't know how the court admonishes him, but in some way admonish him for doing these things. And then for driving by the party's house when he agreed not to do that. He has, to my knowledge, stopped doing that since we got a new order. But again, it's just concerning. It was concerning to me when on the 15th of September, we just had a status conference, and almost as soon as that conference was over, the defendant had to have driven up here because the plaintiff saw him about 4 hours later, and he lives about 4 hours away. So that was kind of concerning that he came up here that quickly after that conference. So, and again, my client is she's wanting to be free of interference and I guess harassment, I would say, in a way, from the defendant.
This is where credibility cracks. Allegations of harassment, rumor spreading, and boundary violations clash with flat denials, forcing the court to warn both sides mediation agreements aren't suggestions, they're enforceable contracts. One misstep now risks contempt, fines, or worse. Viewers, do you think the warnings alone will stop this behavior?
Thank you, Mr. Backlund.
Thank you, Your Honor. In speaking with Mr. Petit, he's denied making negative comments or speaking about the plaintiff to others, the children, family members, and things like that. I understand the motion alleged he discussed a funeral with family members and telling them not to go and making negative comments. And again, he wholesale denies making those statements. When it comes to the driving by the property, my understanding also is that issue has been resolved between counsel and entry of a new order. Plaintiff previously had exclusive use of the marital property, and we further agreed, he's not going to drive by the property or conduct himself in a way that would be harassing or any other nature. When it comes to the mailing, I understand there was a provision in the agreement that Mr. Petit would either forward or change his mailing address. I can't speak to how long that takes to be completed through the post office or through all these entities through which you have auto enrollment or utility companies sending you correspondence and things like that, because they have an address saved on file. And so I understand he's undergoing that process, and the costs associated with getting the mail to Mr. Petit from Miss Petit, I think, are somewhat self-inflicted, Your Honor. She doesn't necessarily need to involve the attorneys to make sure that he gets his mail. She's chosen to do that on her own. I understand, if it's going between attorneys, they can acknowledge receipt of the same. These parties have adult children who see both parties. She could potentially just provide the mail to them or provide some other means, perhaps just dropping them off to my office, for example. Which doesn't incur any cost for her or the parties to relay the mail to Mr. Petit.
Okay. Anything else you wanted to say as to those motions, Ms. McCoy?
Well, I just, as to the last couple of statements, the parties have agreed to not have any contact between each other. So that direct contact, I think, was they were supposed to communicate between counsel, and I think that's why Ms. Petit has provided the mail to me. And then as to their children, I think Ms. Petit has tried to her very best to avoid involving the party's children. So in any case, I don't see why the defendant hasn't changed his mailing address, especially when this house is going to be sold, and his mail shouldn't be coming there anyway at that point. So, but other than that, I don't have further comment. Thank you.
All right. Okay, so there's a number of different aspects to this, but it all arises out of the mediation agreement. Generally, mediation agreements are enforceable absent any kind of fraud or duress or mutual mistake. And I'm not hearing that that's the argument from Mr. Petit. It sounds like it's more of nuance about what's actually been done and whether it actually would amount to a violation of the mediation agreement. So the court finds that the mediation agreement is enforceable and should be enforced. And so what that means to both parties is that to the extent that either of you violates that agreement, and I should remind everybody that these are things that you all have agreed to. Nobody forced you to do any of this. So everybody voluntarily agreed to abide by this. So there shouldn't be any reason why you're not abiding by it. To the extent that either side fails to abide by it going forward, and Ms. Dutzman-Coy, I'm going to ask you to craft an order arising out of all these motions that are yours at least. That mediation agreement is going to become an order of the court now with regard to these specific provisions. So to the extent that either side is violating them, then the penalty is contempt. And contempt sanctions include fines, financial penalties, and can also include jail. All of those are remedies within the power of the court. I take the court's orders very seriously and mediation agreements very seriously. And so to the extent that either side has been found to violate any of those provisions going forward, then they will be subject to fine or incarceration as a penalty for violating it. Looking at the individual allegations, negative comments, that's a difficult provision. People can say and do a lot of things that can be perceived as negative, but maybe not in violation of that provision. What I can say, Mr. Petit, to the extent that you want to toe that line and you want to make comments that get close to being negative or perceived as negative, you're going to be doing that at your own peril. And I'm not making any findings today because I haven't heard any evidence other than argument. But I suspect that if you continue to engage in conduct that could be perceived as negative, we're going to be back here on some type of evidentiary hearing, and the people that you've made those comments to will be called as witnesses. And then I'll make a determination as to whether or not what they say you said or did would be in violation of that. So I would just caution you, Mr. Petit, to the extent that you're trying to kind of ride that line of what's in violation and what's not, you're doing that at your own peril. And I would recommend that you just stop talking about Ms. Petit at all to anybody. That's going to save yourself a lot of time and trouble going forward. And it's what you agreed to. So just stop doing it if you're doing it. In terms of returning to the marital home, it sounds like that issue is resolved, but I would say the exact same thing. There's no reason for you to go back there. You agreed not to do it. To the extent that you continue to do it, then you're going to be subject to contempt sanctions. Same thing with the email. The court is going to allow 14 days for Mr. Petit from today's date to file the appropriate paperwork with the post office if he hasn't already, to establish a new forwarding address. That's not a difficult thing to do. Doesn't take a long time, and the post office will stop sending mail to that address once he files that. So essentially, Ms. Dutzman-Coy, in terms of your motion, the court is granting the relief to the extent the court's finding that those provisions are enforceable, and to the extent that they are violated, then contempt sanctions will be imposed, with the exception of specifically as to the forwarding address. Mr. Petit has 14 days to file that with the post office. The next motion is regarding, and I really view this one, and I'll allow both lawyers to jump in on this, but this one, along with Mr. Backlund's motion regarding the sale of the property, and to me, these issues regarding what needs to happen at the home and getting personal property from the home, complying with what the realtor wants to have happen, how to do that. I mean, in my view, those are all things that we really need to discuss at trial. And those are decisions that I think the court really would be more appropriate for the court to rule on both of your motions in that regard as part of its ruling following the evidentiary hearing. But that being said, I'm certainly open to whatever your positions are, but Ms. Stutz-McCoy, as to that motion.
Thank you, Your Honor. So our motion on that was kind of twofold, and I understand that the defendant also filed a motion for the sale of the property. I think the parties are in agreement that the property will have to be sold. They did agree on that realtor, but as counsel, I have found this realtor to be difficult to work with, and I think of late we've had some more recent communications of late, and he's been more of an obstacle than anything else. Opposing counsel and I have been having discussions about what to do in this circumstance, trying to get the parties to work together so that we can get the property listed. I think we are making some progress. And I think that we have had some changes with regard to the personal property, and what that means for the parties, but those are discussions that we've been having. And I was actually kind of hoping that counsel and I could discuss that more so that we could try to get that resolved. So at this point, maybe that is something that is best reserved for trial if we haven't resolved it by then. But I think that in the meantime, we've been working on that, trying to get this issue taken care of.
Thank you, Mr. Backlund.
Sure. I would sort of pick up first on the court's discussion. The realtor was selected by the parties. He's done significant work for them. And he is listed in the mediation agreement as the realtor that the parties will use to list the property for sale. He's provided some guidelines for the parties to list the property and potentially maximize the sale value, which benefits both parties.
The judge tightens control, enforcing mediation terms and shutting down attempts to reopen settled issues. Missed deadlines, silence, and failure to object earlier carry consequences. The court refuses to relitigate history. This ruling makes one thing clear: final means final, and procedural discipline decides outcomes just as much as facts.
As counsel indicated, we've been working together and speaking with Mr. Heath regarding the listing of the property and going forward. And so I understand the court wanting to address most of that at trial. I do agree that that makes the most sense. And hopefully Ms. Stutz-McCoy and I can knock out most of those issues between now and then so that the court doesn't need to make a decision on that. Because as was stated, it does seem to be an agreement that the property will be sold and a realtor will be used. That realtor has been agreed upon, as I said, in the mediation agreement. So if we can knock out the little variables, I think we can resolve that on our own, hopefully.
All right, so with regard to those motions, the court's going to hold those in abeyance, and the court will address those to the extent that they need to be as part of the overall resolution of the case. Trial. And then finally, we have really two competing motions regarding discovery. Ms. Stutz-McCoy, is your discovery still outstanding, or has Mr. Backlund gotten those answers to you?
No, we provided that on to Mr. Backlund on October the 13th.
So
okay, Mr. Backlund.
Sure, and I'll pick up on that. So we received some responses. There are still some missing elements regarding certain debts, like a student loan. There was the domestic relations verified financial information form, which is one of the documents that we did receive. References a different value from the home, from the market analysis, and so we didn't understand the nexus there of where that new figure came from. And there are some personal property valuations that we had discussed potentially receiving during mediation regarding some motor vehicles that haven't been received yet. But we did receive the batch of documents from counsel for the discovery request, but there are still some elements related to the personal property of the parties that we would need.
All right, Ms. Stutz-McCoy, when can you get those to Mr. Backlund?
Oh, as soon as possible, maybe even today.
Okay. All right, if we say within the next 5 days, like by the end of the week, by Friday?
Yes.
Okay. And And then Ms. Dutzman-Coy, what do you need from Mr. Backlund that you haven't gotten yet?
So, the defendant in his responses to the interrogatories did not provide any details about these alleged third-party relationships. He only answered yes to a detailed question about whether either party had had any third-party relationships. So more details about what he is talking about would be appreciated. He failed to provide employment-related information like W-2s, 1099s, past tax returns, or information about benefits he was eligible for or received, including retirement accounts, whether those were dissipated or not during the marriage. He also claimed to have medical concerns, but did not provide complete medical information, like the dosage of his medications or other appointments. Again, now that he's raising a concern that he's allegedly unable to work because of his disabling conditions, we don't have any information about that, and he didn't provide a medical release either. He also provided no dates for his claims of separate personal property or any factual or documentary support for his claims of inheritance received during the marriage. His father is still living, so I'm not sure what inheritance he would have already received. And he will not provide any information about the 1963 Ford Falcon, despite claiming it is separate property, his father's property, which has caused us to actually try to research that and find out information about it on our own. He also provided no documentary support for his claims of spending some $210,000 on plaintiff's hair salon business. That was during the course of the marriage. That business is no longer operating. And he also did not provide any documentary support for his claims of value for the party's personal property. So those would be the things that we are seeking at this point.
Okay, Mr. Backlund?
Certainly, I know much of the information would be documentary in nature, and Mr. Petit is no longer at the marital home where I understand much of this information was stored. For example, like employment information and tax information belonging to the parties. And so if he's able to access that, if it's in their storage unit or at the marital home, if there's a tax preparer that could provide that information, we may be able to get it digitally and over to Ms. Dutzman-Coy that way. But other than that, he simply doesn't have access to many of the documents that are at the marital home because that exclusive access was granted to the plaintiff.
All right, well, I mean, there's typically when there's motions regarding discovery, one of two things has happened. Either one side has objected and there's a basis for why they're not providing it, or they just haven't provided it. So Mr. Backlund, did you provide responses to Ms. Dutzman-Coy's requests reflecting the information you've just said, or have they just not been answered?
We didn't receive many of the specific requests. We responded generally to the interrogatories. We provided Mr. Petit's responses along with the domestic relations verified financial information form. But until we received the motion, we weren't aware of the shortfalls or the additional information that she wanted to be included.
All right, well, I guess what I'd like you to do is provide responses to Ms. Dutzman-Coy. If he doesn't have it, the response should be, I don't have it. If he believes they're at the marital home, then that should be the response. But Ms. Dutzman-Coy should be able to have some kind of response that she can follow up on. And if you're not going to produce them, then there should be a reason why you're not producing them, so that she can challenge that if she wants, or bring that to her client. So I'm going to ask that you do that within the next 5 days by Friday as well.
Certainly, Your Honor.
Okay, Ms. Dutzman-Coy, I think that covers all of your motions. Is that correct?
It does, Judge. Thank you.
And then Mr. Backlund, would that cover yours as well?
It does. Yes. Thank you.
All right. So Ms. Dutzman-Coy, I'll just ask that you prepare an order reflecting the court's rulings as to your motions, and Mr. Backlund, I'm going to ask that you do the same.
Certainly.
Okay. And I would think you'd be able to agree as to form. If you can't agree as to form, then just submit them under the 7-day rule. That's all I have for this file today. Thank you. All parties are free to disconnect.
Thank you, Your
Thank you, Your Honor.
Cruz versus Cruz. If I could have both counsel put your appearances on, starting with plaintiff.
Elliot Blumberg on behalf of Danny Cruz, Your Honor.
Good morning, Your Honor. May it please the court, Chris Kolumchek on behalf of Carrie Cruz, the defendant.
Okay, we're on the record this morning. Our last hearing was back in August, and arising out of that hearing, the court issued an order regarding some disputed language that was left. The court ended up signing a proposed judgment that was submitted by Miss Cruz and her counsel. Mr. Blumberg, you've objected to that. So Mr. Blumberg, your argument here this morning.
Yes, Judge. The judgment of divorce was to reflect the agreement of the parties. It's entitled Consent Judgment of Divorce. The terms of the judgment were arrived at after an extensive mediation. At that time, Mrs. Cruz was represented by a different attorney. That mediation agreement outlined the general terms of the agreement of the parties. And one of those was clearly the spousal support award that was awarded to Mrs. Cruz, an award that was agreed to by my client. Mr. Kolumchek, in the drafting of his proposed judgment, altered significantly the terms of that spousal support award. It was for a specific period of time, which was to terminate upon the final payment. Mr. Kolumchek's proposed language, what's not proposed, the court signed the judgment, which incorporated his language, which simply said spousal support is to continue until further order of the court after 52 months, which means that at the end of the 52-month period, if my client, wherever he is in the country or the world at this point, would have to then file a motion to terminate the spousal support, have a hearing, and Your Honor would then have to decide whether it was to be terminated. That's clearly not what the parties agreed to. Counsel knew that. I made that aware to him. That was one of the issues that we talked about prior to the preparation of his judgment. So that's the first issue. This proposed judgment simply is inaccurate.
Well, can I stop you for a second? Because we went through, and counsel can correct me if I'm wrong, but I looked through my notes in the order that came out of the August hearing. And at that August hearing, we went through that judgment. We identified some areas where the parties agreed, some language that had to be taken out. And I have I have my marked up copy here from what we discussed at that hearing. And then my order coming out of that hearing was parties agree on all language of judgment except page 7, military pension, parties to consult on language and submit a clean judgment of divorce. If no agreement on that language within 30 days, parties to submit proposed language for that portion only, and court will decide which language. So as far as I'm concerned, after that August 8th hearing, that was really the only issue left. So I don't know why we're talking about spousal support now. And so following that hearing, the court waited to see if the parties were going to be able to agree on that last remaining bit of language. Per the instructions of the court, if there was an agreement, each side was supposed to submit proposed language. I got a proposed judgment from Mr. Kolumchek. I did not get one from you, Mr. Blumberg. So based on my order, my assumption was that there was an agreement or you weren't challenging that anymore. And so that's why the court entered that judgment on September 11th. So with all of that in mind, like, why are we arguing now about whether it complied with the spousal support provisions when we were all set after the last hearing, except for, again, that page 7 military pension language? And I went through the one that we looked at in August and the one that was submitted by Mr. Kolumchek. And aside from that, he made all the changes that we all agreed to. So tell me why we're now looking at this again.
Because it was incorrect, because it's not the reflection of the parties' agreement as stated in.
Why did you agree to it in August then?
My hope is that we would correct all of the errors. And again, this was an intentional statement made by opposing counsel. He had a copy of the mediation agreement. The mediation agreement doesn't say spousal support is to continue for 52 months and then terminate upon further order of the court.
So again, why are we talking about it now? Why weren't we talking about this back in August? Why didn't you say in that August hearing, Judge, that's not paragraph, page 7 of the military pension isn't the only problem we have. We have a problem with the spousal support. Because according to my notes and according to what we talked about, the only thing left for you both to agree upon or discuss was page 7 military pension. So why, what you're saying now doesn't make any sense in light of what we discussed and what was agreed upon at the last hearing. If you had all these problems with the spousal support, why did we agree to it at the last hearing? Because I don't have anything in here in my notes saying that you're objecting to that.
Well, Judge, again, I will try to perhaps make it clear that's not what the parties had agreed to. Effectively, what the defendant has...
That's not answering my question, though, of why you didn't raise it at the last hearing.
Because
why you indicated that you agreed to everything except the military pension part of it.
What we agreed to was the length of time the spousal support was to be paid. That was not a disputed issue. It should have said what the mediation agreement said, because right now, as I just pointed out to the court, at 52 months from now, if an order isn't entered terminating the spousal support, Mrs. Cruz is going to be back before the court and say, spousal support is supposed to continue, Judge, until you sign an order. It's not just semantics.
Your Honor, maybe I can settle this dispute.
Okay.
The spousal support paragraph on page 2 is pretty clear, and that's why I bolded unmodifiable for the amount of $52,000 at the rate of $1,000 per month. This is not going to continue beyond that. That is very clear. What I did here, as it says, through the State of Michigan Disbursement Agency in Lansing until further order of court, because we weren't sure whether or not him being overseas and in a foreign company, they would be able to pay directly through a friend of the court or the Michigan Disbursement Unit. That's what that until further order of the court is referencing, not the amount. The amount is very clear. It's bolded that it's going to be unmodifiable. It's for $52,000 at the rate of $1,000 per month. It doesn't have a time or date set because we don't know when it's going to start. So
That's when it's going to start.
Well, but the point is, once the 52,000 is exhausted, it's very clear. There is no, it's a set amount. I don't know. I'm not trying to mislead anybody. If he wants until further order of the court removed, I don't think it really matters either way. But he's basically already threatened me with a bar complaint. And, you know, I have no issue over that. I tried to call him and say, what are your issues? We could just strike this if you want. And he told me he didn't want any favors from me and would refuse to go through what his issues were. So at this point, I mean, if it's just until further order of the court of paragraph on the spousal support on page 2, if that's stricken, we have no objections.
All right, Mr. Blumberg.
Judge, let me say this, and I'm going to be very careful about my comments. I think you know that I've appeared before you for years and that the representations being made by counsel are not accurate. I have had more discussions with his paralegal secretary than I have had with him since his involvement in this case. It's simply not true. If he strikes that, I'll be satisfied with that. The other and remaining issue is the award of survivor benefits to his client that was not granted in the mediation. Again, it's not a question of what it appears to me is simply attempting to put things in that were not a part of the agreement, of the consent mediation agreement. And that's what I take exception to. She's not entitled to that. She has kept her entire military pension. She has gotten a significant portion of my client's military pension. And now the award or the potential award of survivor benefits will significantly reduce the amount of my client's monthly retirement pension. That's not what was discussed at mediation. That was not what was agreed to. And to put that into the judgment is a misrepresentation of what the parties agreed to. And that was the thing that we talked about when we were last before you.
All right, so I had a chance to review the written submissions of the parties. I had a chance to review our previous hearing from August. And I looked at, again, the proposed judgment that we all looked at in August. I've got my notes, the things that I crossed off, the things that the parties agreed to take out of that judgment. We went through pretty much paragraph by paragraph. I issued a status conference order arising out of that hearing, which I've recited for the record here today, that indicated that the only remaining issue was the language on page 7 regarding military pension. The court directed the parties to either agree on language in that provision only, because everything else was settled. If they couldn't agree, then the parties were to submit competing language within 30 days, and then the court would make a decision without further hearing. And that was also something that was put on the record. The court waited the 30 days. Mr. Klomchek submitted a proposed judgment on, I believe, September 4th, which was the 30 days from our hearing, which was August 4th. The court signed that judgment on September 11th. I did not receive any competing language or competing proposed judgment from Mr. Blumberg. I didn't receive any kind of written objection within that 30 days to any other provision of what we discussed on August 4th. So in my view, to the extent that there were any objections, they should have been raised at the hearing in August or in the 30 days subsequent, and that there should have been a proposed judgment with competing language submitted by Mr. Blumberg's office. None of that was submitted. I'm not going to continue to reopen and discuss things that, as far as I'm concerned, were settled on August 4th. If there were any issues remaining, everybody had a fair chance to raise them at that hearing. It's very clear to me, based on my notes, that the only remaining dispute with regard to the judgment submitted by Mr. Klomchek was the language in the military pension as to on page 7. So I'm going to deny the plaintiff's motion for relief from judgment. I have stricken the language suggested by the parties and agreed to by the parties here with regard to the spousal support. I've crossed out the until further order of the court language. I've initialed that with today's date on the copy that I signed for Mr. Klomchek. If parties want an updated copy, they can contact the clerk's office. But otherwise, the judgment will remain in place as signed by the court. That's all I have for this hearing today. All parties are free to disconnect at this time.
Judge, can I just ask one final thing? If
Sure.
the judgment does not contain the language, this is a final order, we would ask that the court write that in.
Across multiple cases, one message dominates: final orders matter, deadlines matter, and silence after agreement means consent. Attempts to relitigate settled issues fail fast in this courtroom. The gavel closes doors decisively here. If you want more real courtroom drama, sharp legal insight, and unforgettable rulings, like, comment, and subscribe now.
It does indicate that it is a final order that disposes of the last pending claim and closes the case.
Thank you.
Okay, all right, thank you. That's all for today. So we'll go on the record in Purcell versus Purcell. This is file number 2419939. If I could just have both counsel put your appearances on, starting with plaintiff.
Good morning, Your Honor. Brooke Robinson appearing on behalf of the plaintiff, Kendall Crostel, who is seated to my right in my conference room via Zoom.
Good morning, Judge Elliott Blumberg on behalf of Melissa Crucell, who's appearing via Zoom from my office.
All right, thank you. We're on the record today for a status conference. In this case, I see that the parties did participate in mediation back in October and reached agreement on some matters. But Ms. Robinson, as of today, can you tell me where things are at from your side and what you would like to request for scheduling to get this resolved?
Yes, Your Honor. We did have a partial agreement, but we are still negotiating all property aspects at this point. I understand that the couple's home has now sold, so that's going to be a new bit of information and new property to add to the pot. So that will probably need to be discussed between me and Mr. Blumberg, but we do not have a resolution at this time.
All right, so from your side, do you want me to just get this on for a bench trial hearing date?
Well, I haven't spoken to opposing counsel about this recently, but I wouldn't mind if we wanted to maybe take some more time and try and mediate this between us or negotiate between us. But if we just want to go to trial, then we just want to go to trial.
All right, thank you, Mr. Blumberg.
Well, Judge, there are a number of issues. There was, prior to both counsels' involvement in this matter, a document that was prepared by the plaintiff, which I guess purports to be a post-nuptial agreement. I don't know if they're seeking to enforce that or not, but that's certainly an issue for the court. We filed an objection to your ex parte order determining that the child should be enrolled in a school. We've not had a hearing on that. We've certainly, with all due respect, took some exception to the fact that you made that determination without the benefit of a hearing. There are child custody and parenting time issues. So I'm not opposed. Counsel and I have the ability to talk, but some of these issues I think are going to require the court's review and determination.
Okay, I think what I'd like to do then is just get a date set. Parties are free to continue to negotiate, but if we have a date for an evidentiary hearing to at least address property issues and assets and debts, that's something that we can take care of. And then obviously the custody support and parenting time will proceed on its own track. So in terms of being ready for a hearing on property issues, Ms. Robinson, how far out would you like the court to set that? And how much time do you think we would need, a half a day or a full day?
I imagine we could probably do it within the next 30 days, and we would at least need a half a day.
Okay, Mr. Blumberg.
I'm just thinking, yeah, perhaps within 30 days. And if we're only going to address the property related issues, again, we still have this outstanding issue of this document that was never presented to the court for enforcement. So it seems to me that that's an issue that needs to be addressed prior to conducting a trial on property. The other thing, though, Judge, I would ask the court, my understanding is that there is a prospective closing date of November 20th for the sale of the marital home. We would simply ask that those funds either be held in escrow or in the trust account of either counsel and not to be dispersed until the court rules on some of these issues.
Okay, so first of all, I guess with regard to timing, I don't think I can get a date within the next 30 days. So I would be looking at more 60 to 90 days. And I would set it for a half a day evidentiary hearing at that time. Ms. Robinson, I don't know about this post-nuptial agreement. Is that something that you're going to be seeking to have the court enforce, or is that?
No, I don't understand why that's still brought up. We obviously do not have an agreement there anymore, so we've been negotiating completely outside that agreement with the expectation that we're starting fresh. So that's not something we're looking to enforce at this point. We just want to negotiate this and get it done.
Well, that's
Okay,
great.
so okay.
I'm
All
happy.
right, so that takes It takes care of that. Ms. Robinson, do you have any objection to, I mean, it makes sense to me that funds from the sale of the home should be kept in escrow until the court determines, or there's an agreement.
Yes, I would agree with that. It was actually something I was going to speak with Mr. Blumberg about later on today.
Okay, so I'll just ask counsel. It sounds like we have an agreement on that. I'll just ask the two of you to work together to set that up. And then I will set this for like I said, a half a day hearing date at 60 to 90 days out. And I'll set it for one final status conference on my motion day immediately preceding whenever that bench trial date is, just on the off chance that the parties are able to reach an agreement, then we could use that date to potentially take proofs, and we'll go from there. Ms. Robinson, any other dates that I can address for your side here today?
No, Your Honor. Thank you very much.
Mr. Blumberg?
Judge, I'm sort of, the wheels are turning slowly today in my mind, so bear with me if you would. I truly think the issue of custody and parenting time is one that needs to be reviewed and determined, because what's in place now is sort of a product of that document that's no longer seeking to be enforced. We haven't really gone through the referee process, but I know it's not your usual practice, but if we could schedule this for a one-day trial, 60 days or 90 days out for all issues, that would probably be the most efficient way to resolve this case.
Well, do we have any hearings set before the referee at this time?
I don't believe so.
All right. Ms. Robinson, what's your view on that?
If we are going to reopen parenting time and custody, yeah, I believe that we would have to add that to all the property issues as well. From our end, we were of the expectation that we were doing okay with property and with parenting time and custody.
Ms. Spillane, can you tell me what, I mean, I'm just trying to look through the file here on the fly, but what's the current order in place on custody and parenting time?
Sorry about that. It's not my case, it's the other case manager, so I'm not exactly sure what they've got going on. I can get that other case manager if you'd like.
Judge, the parties are sharing custody on a week-on, week-off basis. That's the current agreement.
Okay, so yeah, so what I see is back in March of this year, by agreement of the parties, joint legal and physical custody. So we have an order in place that was agreed to by the parties. I understand, Mr. Blumberg, if you've got an objection to the schooling issue, then that's something that we should get set for a hearing on your objection. But in terms of, I mean, are you saying that you want to change the current arrangement that was agreed to by the parties?
Yeah, the facts are very, very different now than they were at the time when that was entered into. Mr. Crusel's got a girlfriend that he's living with. Nobody lives in Charlevoix County where the child's going to school. Just the facts are very different. The situation's very different. And candidly, we don't think that this arrangement's in the best interest of the child. I'm not sure, because it's not a final order. I don't know that we need to establish a change in circumstance, but we clearly believe that there has been.
All right, well, it's my view then that that's something that needs to go through the front of the court and follow the referee process. So to the extent, Mr. Blumberg, that you would like to change the current custody, I just request that you file a motion, and we'll follow the normal process on that.
Understood. Thank you.
And then you said that you have filed an objection to the ex parte order?
Yes.
See that.
I don't see that in the file. That ex parte order was entered in August 28th, and there is no objection in the file.
I mean, I know we filed it, because,
Hold on, let me just check 1 second.
I don't see an objection
I'm just talking to the clerk. We don't have any record of an objection
unless it
filed.
was just like recently filed and I didn't
No.
see it.
Unless, when did you file it?
the same week that we got your order. I'll send a copy to everybody. I mean,
I don't see an objection in here.
Yeah, the clerk's saying that there isn't any record of an objection filed. So if you filed it, then we need to get that corrected. And if not, then I mean, I would assume that's why we haven't scheduled a hearing on that yet, is because we don't have it showing as an objection.
I know it was done. Okay, I'll find it and send it over to everybody.
Okay. All right. So once that gets filed, we'll set that for a hearing. If it was filed, you know, I guess Ms. Robinson, to the extent that you're going to have any kind of objection as to the timing of that, then you're fully able to raise that. If it wasn't filed for some reason, obviously, if it was filed correctly and we didn't do something right, then that wouldn't give rise to a challenge for timing. But we can address that once we get that part.
Thank you.
Resolved. So, okay. So in terms of custody, that's something that defendant will need to file a motion on to challenge the current order that's in place with friend of the court. In terms of the objection, Mr. Blumberg, I'll just ask that you communicate with the clerk's office to determine if that was filed, and if not, whether you want to file that. And then again, in terms of property issues, the court will set it for a half-a-day bench trial at 60 to 90 days out, with a status conference on the motion day immediately preceding bench trial date. And I think that addresses everything. All of that will go out in a status conference order to the parties in writing. And both sides are free to disconnect on this file.
Thank you.
Thank you.
Okay, we'll go on the record in Vander Kirchhoff versus Vander Kirchhoff. This is file number 2419800. If I could have counsel put your appearances on, starting with plaintiff.
Reagan Richards, Legal Services of Northern Michigan, on behalf of plaintiff Haley Van Diekershove, who's appearing via Zoom.
Mr. Blumberg, you were muted.
Apologize, sorry. Elliot Blumberg on behalf of Nicholas Vander Kirchhoff, who's appearing via Zoom from my office.
Okay, we're here today to schedule a hearing on Ms. Richards. Your client has filed an objection to the child support recommendation. Is that correct?
That is correct, Your Honor. We have also, my client just found out that Mr. Van Diekershove's employment has changed since the child support recommendation, so I'm not sure how Your Honor would like to deal with that. But our objection is primarily to the child care cost. Mr. Van Diekershove's hours have changed, which will change the child care calculations.
Okay, Mr. Blumberg?
Judge, we have a trial scheduled on the 10th of this month. I would think that all of these issues could be addressed at that time. Again, Ms. Vander Kirchhoff has not paid any child support in any amount, regardless of the recommendation. So again, we were going to be before you on the 10th of November. I thought maybe that would be the best time to go through all this.
All right, Ms. Richards, do you have any objection to the court taking testimony and deciding your objection as part of the current hearing that's scheduled?
No, Your Honor, that's fine with me.
Okay, all right. So, and it looks like, Ms. Richards, did you already kind of include that in your trial brief?
I did a trial brief for the evidentiary hearing before referee legal, and the issues have not changed significantly, so that trial brief for the child support issues would still be relevant.
Okay. All right. Let me just, because we currently have it set for half a day. I want to make sure or see if I have anything scheduled the rest of the day in case we need more time with this added issue. So everybody just hold on for 1 minute. Okay, so I do have matters scheduled for the afternoon. So we'll proceed on the 10th with adding this issue, and we'll get as far as we can. Hopefully we can get all the proofs in on Monday morning. So that's how we'll proceed with the objection. Ms. Richards, anything else I can address for your side today?
No, Your Honor, thank you.
Mr. Blumberg?
No, I think we're all set, Judge. Thank you.
Okay, all right, thank you. All parties on this file are free to disconnect. Okay, Ms. Stutzman-Coy, I'll ask you first, since it was your motion. Have you been able to resolve any issues?
Yes, Your Honor, we have, and I would be able to put an agreement on the record if I may, Your Honor.
Okay, please.
Okay, so the parties agreed as to the plaintiff being able to visit the residence to obtain her personal property on Thursday, November the 6th at 4:00 p.m. The parties have agreed on their friends Billy and Chelsea to be there with them. If they're not available, plaintiff's brother Seth may be there, and the defendant's friend or someone of his choosing may be there as well. The plaintiff is going to get her clothes, her shoes, her books, the rest of her bathroom items, the spare bed, her baskets with socks and etc. and her underbed storage. She will ask the defendant if she has a question about anything, and if there is a dispute, she'll leave that item so that the parties can resolve it later. And then as to the marital expenses, the parties have a joint savings account that I believe that they would be able to pay their marital expenses out of until the end of the year. But plaintiff agrees that she'll contribute to the marital expenses, and the defendant would be responsible for essentially the mechanics of paying those expenses, making sure the bill actually gets paid. The parties would also seem to agree to a mutual temporary restraining order conserving the marital estate. And I think we'd like to revisit the issue and discuss it some more details before January. The parties are also amenable to using community mediation services, but continuing negotiations between themselves.
Okay, Mr. Slocum?
That was a full statement, recitation of the agreement. It was very well said. I don't believe there's anything more to it.
Okay, Ms. Stutzman-Coy, are you going to reduce that to writing and submit that as a stipulation in order for the court?
Yes, Your Honor.
Okay, all right, very good. Anything else, Ms. Stutzman-Coy, from your side on this case?
Not for today, Your Honor. Thank you.
Mr. Slocum?
No, we're all set.
All right, thank you, and thanks counsel and the parties for working to resolve this, and all parties on this case are free to disconnect.
Thank you.
This custody fight opens with explosive accusations, mental health claims, and a father insisting he's being falsely accused. The judge immediately cuts through the emotion, demanding clarity. This case isn't about drama, it's about children caught in the middle. Subscribe, like, and share for more intense courtroom breakdowns you won't believe.